All right, last video. So this one obviously is labor law. And so at the outset, I should point out some of the differences between professional and college athletes. And as it pertains to this discussion, the primary difference is that college athletes are considered primarily to be a student. And so while you might conceptualize college athletes as being professionals in any number of ways, for example, the amount of time they devote to excellence at their craft, whatever their sport is, the fact that they may have chosen their school on the basis of that sport, and the fact that they are compensated, albeit indirectly, for participating in that sport, the court still considers them to be students first. And I should point out, and I mentioned in a previous talk, that the idea of student athletes, and indeed the term, came from the NCAA itself as part of a lawsuit over the death of a player. His widow is from, I think, Fort Hays State, Fort Collins State. It was a school in Colorado. The school itself doesn't matter, but what matters is that a football player in Colorado, a college player, died as a result of injuries that he sustained while practicing football as a member of that college's varsity team. And his widow sued the university for workers' compensation. And so the NCAA crafted this idea of student athletes, that they are primarily students, that they are not employees of the university, to help prevent universities from having to pay out workers' compensation claims. And so that has been upheld. And so your college athletes then are considered students first. They're student athletes. And so that then matters in that they're not employees of the university, so they can't do things like engage in collective bargaining to change the conditions of their workplace. They can't obviously get workers' compensation. They have less rights to continued medical care after they're done with college, those kinds of things. So that's where it matters. So this discussion then is going to be about professional athletes, because since they're employees of their particular team, so if you are a player for the Green Bay Packers, you are then an employee of the Green Bay Packers. And so because you're an employee, then you're entitled to certain rights. So as it pertains to labor law, then labor, those are the employees, right? And so then this is primarily going to center on professional sports. So as you can see there, the idea behind labor law is to govern the workplace and to cover the rights and responsibilities of employers and employees. Because one of the things that can happen in the workplace is that there can develop a fairly antagonistic relationship between employer and employee. And one of the reasons for that, while ultimately both the employer and the employee want success for the business, because if the business doesn't do well, the owner doesn't make money, and obviously then the employees don't either, because then they'll be out of a job. So ultimately both of them want the same goal. They both want the business to do well, but how you get there may differ in terms of the different perspectives, right? So the employer wants to maximize profits, and so one of the ways that they can do that is by reducing costs. So, for example, they can reduce salaries, or they can keep salaries as low as possible. And by reducing those costs, that helps them to generate higher profits. The employees, on the other hand, of course, want the business to do well, want the business to have lots of profits. But the employees may say, well, yes, we want the business to succeed. We also want to make as much money as possible as part of that. And so the employees may say, if we make more money, we're going to be happier, we're going to be more productive. And so by being more productive, then that'll enable us to generate more money, be a more profitable business. So there can then develop this antagonistic relationship between the employees who want higher salaries, for example, or different workplace conditions, maybe more days off, maybe different health insurance, those kinds of things. And the employers, oftentimes in an attempt to minimize costs, may not want those things, and so then the two sides then can be at sort of a loggerheads. They can dislike each other, and there can be some disagreement there that can be problematic. And so the idea behind labor law is to minimize that as much as possible. So one of the ways to do that is to generate a collective bargaining agreement. So a couple terms on there. So you can see unions. So those are trade organizations that represent employees. So an example of a union in professional sports is the NFL Players Association. So all of the big four leagues are going to have players associations, so MLBPA, NFLPA, etc. And so those are going to represent the interest of the players when they are trying to strike a collective bargaining agreement, or CBA, between the Players Association, between the Players Union, and the owners in that case. And so CBAs then are contracts, as you can see there, between an employer and a union. And so what CBAs do is they set minimum standards in areas like wages, benefits, so benefits including things like health insurance, life insurance, those sort of things, health and safety conditions, so what kind of equipment is allowed from a sports standpoint, who gets to make the call on return to play. So think about things like concussions, for example. What's the return to play protocol after something like a concussion, vacation time, and then also dispute resolution, grievances, those kinds of things. So if players are suspended, if they're fined, how those fines are levied, and then if the player disagrees with that fine or with that suspension, how they can be appealed. So all of that stuff then is in the collective bargaining agreement. All right, so as always, there's a little bit of a history lesson included in this. So in terms of the development of labor law, so workers started to organize in the U.S. in the 19th century, so in the early 1800s. And so the first time where it comes to court and sets a precedent that matters actually comes from the Philadelphia Mayor's Court, and the precedent-setting case there of the cordwainers in 1806. First of all, I should tell you what a cordwainer is. Those are boot and shoemakers. And so what happened there essentially was that a group of boot and shoemakers in Philadelphia decided that they wanted to get paid more. And so they went through and organized throughout all of the different shoe factories. That may be overstating the case. The facilities may not have been that big, but shoe production facilities. There was some organization among employees, and they all agreed to walk out. They all agreed to go on a strike. And so again, the reason they were doing that is to increase their wages. And so the idea there is that the employees, the boot and shoemakers, if they walk out, then they can exert some economic leverage on their employer, because obviously if they aren't producing anything, then the employer is going to lose a lot of money because he doesn't have anything to sell. And so the employees then are hoping to force concessions from the employer by having a work stoppage. And so, in fact, that's what happened. So all the boot and shoemakers go out on strike in Philadelphia in 1806. And so what the employers did was they said, okay, well, if all of you are on strike, we're going to find people to fill in for you. And so the workers, the fill-in workers who came and worked while the original employees were striking became known as scabs, which is a term oftentimes still thrown around today during labor disputes. So you've got these replacement employees that have come in. And so the organizers on the part of the employees, the boot and shoemakers, actually start to threaten the replacement workers, right? Which is not an uncommon thing to happen during labor disputes. So they start to intimidate and threaten the fill-in employees during this big strike. And so as a result of that, 8 leaders of the group are arrested and brought to trial. And so what ends up happening there is that they are all convicted. And what they're convicted for is engaging in a conspiracy to keep their wages up. So all 8 of those leaders of that boot and shoemaker strike are found guilty of engaging in a conspiracy to raise their wages. Each of them was fined $8. If we adjust for inflation, it's approximately $150. And then they were forced to pay the cost of their trial. So in finding them guilty, the judge said, quote, "The defendants are not indicted for regulating their own individual wages, but for undertaking by combination to regulate the price of labor of others as well as their own," end quote. And so what you might have noticed there when the judge said that the boot and shoemakers were found guilty because they undertook a combination, right? So think back to what we talked about with antitrust law. So the 3 C's of antitrust law: combination, concert, or conspiracy. And so you see, even though antitrust law doesn't come about until 1892, so at the end of the century, you see some of the same ideas there, that it is not acceptable to manipulate the market by working together with other people who do the same thing that you do, whether you are a producer. So we talked about it in the context of cable companies. So, whether you're a producer or whether you're an employee in this case, The court basically felt that that was manipulating the market in such a way that didn't allow the free market to function as it should, and so because of that, that was something that was illegal, and so again, the organizers of that strike had fines levied against them. But in 1846, the Massachusetts Supreme Court, that's what Mass SC stands for, in a similar case, ruled that the doctrine of conspiracy didn't apply to labor unions because combination itself is not illegal, only a combination to accomplish a criminal purpose. And so inflating your wages or increasing your wages is obviously not something that is criminal. That's something that you're allowed to do. And so because you are engaging in combination with others to do something that is perfectly legal, well, then that combination is legal. And so effectively that ruling in 1846 legalized the American labor movement. So you start to see an increase in the number of unions, in not unions per se, but you start to see an increase in labor organization in the latter half of the 19th century, in part because of that ruling. So a different way of conceptualizing the role of the free market, I guess, is a way to think about that. So what ends up happening then is that you start to see more employees engaging in these types of actions, engaging in strikes, engaging in walkouts, picketing, those sort of things. So strikes and walkouts are synonymous, but picketing is something different that we'll talk about here in a second. And so what the employers do then is they start to turn to private security forces. So one of the really prominent ones was called the Pinkertons. And so the idea with the employers hiring these private security forces is to suppress strikes. So they keep their finger on what's going on at the work site, and then if any employees are getting ready to start any kind of labor stoppage, well, then they can violently suppress that. So they may follow the workers home, a number of other things that they can do to be physically intimidating to try to minimize the risk of strikes for the employers. So what ended up happening at the Homestead Mill, which is in Pittsburgh in 1892, so this also harkens back to what we talked about with antitrust suits. So remember, the idea behind antitrust law was that you have one or two entities that can control production of an entire market worth of goods. So for example, we talked about U.S. Steel, controlled by Andrew Carnegie, could set the prices for steel. Well, the Homestead Mill in Pittsburgh is one of Carnegie's mills, and so he'd hired the Pinkertons to ensure that there were no strikes, basically that production would continue on time, that the workers would not be able to work together to increase their wages, those kinds of things. And so the Pinkertons were pretty good at their jobs. They were pretty effective at suppressing strikes. But then in 1892, there's a really big strike at the Homestead Mill, and it breaks out into violence. And so the ultimately gunfire is exchanged on both sides. So the result of the initial skirmish leads to 9 workers being killed, as well as 3 Pinkertons being killed with that exchange of gunfire. And so what ends up happening then is that the governor orders the state militia to the mill, and the workers are then forced to retreat. So the workers are then kind of just outside the mill, picketing, if you will, at that point. So replacement workers are brought in by train, and after 4 months without employment, the workers have to give up and ultimately return to work. And another really famous incident comes from Colorado, the Ludlow coal mines in 1914. And what happened there is that, so you got workers striking, and that's what the picture is from in the lower right. That's from the Ludlow coal mine strike. So workers are out on strike, and they're above the mines, and they have established these camps where they've got their entire families in these camps. And so the state militia is called in to try to break up this strike. And so they attack the group of striking miners and their families. And so ultimately what they do is that the militia starts to fire. So you can see they've all got rifles. They start to fire into the camp early in the day. And then at dusk, the militia descends on the camp and sets the tents on fire where the striking miners had been living. And so then obviously the miners and their families start to kind of flee to the surrounding hills, and the state militia starts shooting the workers as they're running away. And on top of that, as mentioned, they're setting fire to all of these tents. Several families had basically dug pits underneath their tent because, as mentioned a second ago, the militia started firing pretty early in the day. And so to avoid the gunfire, the families start digging pits underneath their tents, and so they hide out, below the tent in order to avoid the gunfire. Well, ultimately, some of those pits collapse, and so the result is in one particular incident, one of the pits that collapsed buried 11 children and 2 women alive. And in all, 66 men, women, and children were killed during the strike. And so you start to see these increasingly violent, increasingly contentious strikes. Ultimately, that compels Congress to get involved, and we end up with the Clayton Act of 1914. And what the Clayton Act says is that unions are not subject to the Sherman Antitrust Act. So remember, we talked about the Clayton Act with the Sherman Antitrust Act in terms of treble damages. As it pertains to this particular discussion, though, so one of the things that employers would do is to try to seek injunctions against striking workers, to try to get the court and the state militia involved to suppress the strike, basically declaring it illegal using the same logic that was used in the Cordwainers case in 1806, that the workers were engaged in combination, concert, or conspiracy, in that case, to artificially inflate their wages. So that idea of combination, concert, or conspiracy becomes enshrined in law in the Antitrust Act in 1892. So once that happens, then employers start to turn to the Antitrust Act and say, well, the employees are engaged in combination, concert, or conspiracy to artificially inflate their wages, and so therefore that's illegal, and so the state militia can be called in to try to break this up. And so the Clayton Act officially says no, that employees are allowed to do that unions are not subject to that law. Then we get the Norris-LaGuardia Act from 1932, and so that's going to limit federal injunctions to prevent peaceful stoppages. So if the employer can prove that there is a threat, an imminent threat of violence, then they can still get an injunction. They can still call in the state militia or other police forces to break up the strike. Because one of the things to keep in mind about these strikes is that as the workers are striking around the work site, while the employer can actually get replacement workers to come in, if you've got all of these people surrounding the work site, that can be pretty intimidating. Even if they're willing to physically allow you, which they legally have to, but if they're willing to physically allow you to cross that picket line and go into the work site, they're going to be shouting things at you. It's going to be really demeaning, all of those sort of things. And so that as the replacement employee, you're probably thinking, this may not be the best place to work. And so that's why employers would seek out injunctions, is to try to break that up. So it makes it easier for them to find replacement workers, and they don't have to meet the demands of the workers that initially walked out. The Wagner Act of 1935, ultimately it's going to be amended in 1947 and become the National Labor Relations Act, which is what NLRA stands for. But one of the important things for this discussion is it says that workers are allowed to join or assist unions. And then the Taft-Hartley Act of 1947 prohibits union pressure, so that people can't be compelled to join a union in order to work at a particular site. All right, so the National Labor Relations Act, as amended in 1947. So a couple relevant sections that we'll talk about. So Section 7 first, then Section 8. So Section 7 assures workers of the following rights that include the ability to form and organize labor unions, the ability to become a member of a union or refuse to join. So you can work at a site, but you don't have to be a member of the union, and it's not allowed, it's illegal, for the union to say, like, yeah, you got hired, but you need to pay your dues, you need to join. They're not allowed to do that, again, under Section 7 of the National Labor Relations Act. Also allows workers to bargain collectively, so to reach those collective bargaining agreements, and allows them to engage in concerted activity for the purpose of bargaining. So one of the things that employees need is leverage. They need a way to force the employer, force the owner to make some concessions. And so there are different ways of doing that, but effectively what happens is that the employees leave the workplace. They refuse to work. So you get a work stoppage, right? So there's different kinds. So the first one on there is a strike. And so a strike is the same thing. I keep talking about workers like walking off the job, engaging in a walkout. That's the same thing as a strike. So it just means that they leave the workplace. They stop working. But strikes are usually combined with picketing. And so the football players there, that comes from a strike from, I think, 1992, because that's Dan Marino there. So the NFL strike from '92. And so what you've got there is picketing. So you got players walking around holding signs so you can see the signs of the things that they're looking for. So they are looking for better pension for players. They're looking for fairness in their contracts, probably relating to something like free agency. Not sure. But what you do with picketing then is you try to generate public awareness for your cause, to try to generate public support, which then exerts pressure on the employer. Because if everybody thinks that the NFL owners are treating the players unfairly, well, then they're less likely to watch the games. They're less likely to buy tickets. And so then that exerts economic pressure on the owners. So strikes and picketing typically are combined. Boycotts are also known as sympathy strikes. So a boycott is where you get related sets of employees striking. So, for example, if the professional baseball players really feel like the NFL players have been treated very unfairly, then they can engage in a strike of their own. And it's not that they're trying to change anything about their own workplace, but they've engaged in a work stoppage to try to increase the leverage of NFL players. So that would be a boycott or a sympathy strike in this context. So you're probably familiar with the concept of boycotts as you just don't buy something. But in this context, as far as worker relations go, boycotts are the same thing as sympathy strikes. All right. So then Section 8 deals with unfair labor practices. So if an employer violates any of those rights from the previous slide, then that's referred to as an unfair labor practice. And Section 8 gives some more specifics on what unfair labor practices are. So, for example, they're attempting to dominate, interfere with the formation of, or damage finance and support of a labor union is something that would be considered an unfair labor practice. So a really common type of unfair labor practice that ownership engages in sometimes is if there's a team. So I'll give you the example in the lower right. So the Austin Ice Bats, that's a hockey team, a professional hockey team that I worked for right out of grad school. So I was their head athletic trainer, in that I was their only athletic trainer. But they played in the Central Hockey League. So it was a AA minor league hockey team that was loosely affiliated with the Minnesota Wild. I think we got one of their players at one point, was a goalie. But that league, the Central Hockey League, or the CHL, didn't have any sort of a union. They didn't have a players association. And so toward the end of the season, the players were trying to start one. And so you kind of hear some rumblings in the locker room and in the athletic training room about starting a union, and would you guys be interested, and all of that kind of stuff. And so interestingly then, the owners turned around and they said, well, if you guys decide to start a union, that's probably going to bankrupt the league. And so that's actually one of the things that's not allowed under the National Labor Relations Act. So things like threatening bankruptcy, threatening firing, or layoffs are not allowed. Those are considered unfair labor practices. And in addition to those, at times employers will reward employees who try to undermine the union. So they'll go to maybe the captain of the team and say, hey, if you in the locker room are like, here's all the reasons you guys shouldn't vote to join the union, then I'll make sure to give you a bonus in your next check or across your checks for the rest of the season. So inducing employees to go against the union, that's also something that's considered an unfair labor practice and that they're not allowed to do. And it was only years later, taking a sport law class, where it kind of hit me all of the stuff that was happening as the players were discussing formation of a union that were ultimately unfair labor practices. So ownership, again, threatened bankruptcy of the league. They threatened layoffs in that they told the players that if the rosters, if salaries increased, then the roster size would have to decrease, and obviously that would be bad. Less jobs in that sense. And then to some extent, owners were engaged in undermining the players in terms of kind of going, the example I gave you of going to some popular players in the locker room and being like, hey, you guys should really, try to discourage formation of this union, but act like it's your idea. So that's one type of unfair labor practice that employers engage in. Another example is actually making players belong to the union. So that happened with the Arena Football League, if you're familiar with that, in the early 2000s. And so what the league did was they basically required players to join the union, and then the league controlled the union because the players didn't really have a whole lot of leverage against, or yeah, if you're in the Arena Football League, it's because you couldn't make it in the NFL, and you're probably just pretty excited to be playing football, and so you probably don't have a whole lot of leverage. If you threaten to strike, there aren't going to be a lot of people that are going to be super mad that the Arena Football League isn't playing. So the players don't have a whole lot of leverage. And so the question I have for you, of course, then is why would ownership of the Arena Football League sort of coerce players to join the union? And the answer to that deals with what we talked about back with antitrust law. So remember that professional sports does a number of different things that are violations of the Sherman Antitrust Act. For example, we talked about drafts, that those are violations of the Antitrust Act because, since the NFL draft just recently passed, once a particular team drafts you, that's the only team that you can bargain with over your salary. And so the idea of a draft then, from an ownership standpoint, is to depress salaries, because if that player, the best college players coming out, so this year if it was, for Joe Burrow or the defensive end from Ohio State, whose name escapes me, but let's stick with Joe Burrow. So if he were able to bargain with every team in the league as opposed to just the Cincinnati Bengals, obviously he could get a significantly higher contract offer, right? And so the reason that violation of the Antitrust Act is allowed is because of collective bargaining agreements and non-statutory labor exemptions, which we also talked about in the antitrust chapter. So anything, again, violations of the previous slide, those are unfair labor practices. So I mentioned the most common ones. Other things that employers might do: discriminate against employees based on their labor union relationship, basically give them worse shifts, not promote them, things like that because they're members of the union. Forbids retaliation for filing unfair labor practices. So one of the things that employees might do is say that the employer is not abiding by the CBA, that they're not getting the vacation time that they wanted, they're not getting the medical care that's part of the CBA, those sort of things. Those would also fall under unfair labor practices. And then the last thing on there is that both sides in this case have to bargain in good faith over things like wages, hours, terms of employment, as you'll see in a few slides, the mandatory subjects of a CBA. So bargaining in good faith, effectively bargaining in good faith, the idea there is it means that you are coming in with a fair mind, that you are actively trying to seek a deal. As opposed to, if you're not bargaining in good faith, basically you would show up in the negotiations, or not show up at all. But if you do show up to the negotiations, you'd basically just sit there and go, nope, not doing that, nope. You're not willing to make any concessions. That's not bargaining in good faith. So both sides have to be willing to bargain in good faith. So Section 8 also says some things that unions can't do. So they can't coerce employees to join, like as a condition of employment, and they can't cause the employer to discriminate if people fail to join the union. In terms of there are different kinds of strikes. So you can see an economic strike is the first one on there. That is a strike to increase your wages. So that's like the cordwainer strike when they walked out. What they were trying to do is increase their salaries. As opposed to an unfair labor practices strike is where the employer has engaged in any of those things from the last slide, so from the Section 7, or any of the stuff I talked about previously, then those are unfair labor practices strike. And the reason the two are different is because if employees are striking over unfair labor practices, then they can't be permanently replaced. As opposed to if employees walk out or if they strike simply trying to increase their wages, well, then they can be permanently replaced. So there is an important distinction between the two. In terms of the other two terms on there, so feather bedding would be where employees walk out or strike in an attempt to get the employer to hire more people than necessary in order to do the job. So that happened for things like construction companies in the Northeast, like in New York. Workers might decide to strike to try to get the employer to hire more people, hire your cousin, your brother, etc., kind of a thing. And then sit-down strikes are so you can't do feather bedding. That's illegal. So you can't force the employer to hire more people than is necessary for the job. And then the other one on there, sit down strikes, is where the employees physically sit down at their workstation and thus prevent the employer, like they're physically preventing the employer from continuing their business. So if you work at a factory and you just sit down at your workstation and refuse to move, such that production has to shut down, well, then that's something that's illegal. You're certainly free to walk out. You're free to protest your working conditions, to picket, all of those things. But the employer also has the option of replacing you, right? Certainly, even if it's only temporarily, they have the option of replacing you. And so if you make that impossible, engage in a sit-down strike, that's something that is not permitted. All right. So the National Labor Relations Board, as you can see, administers and enforces the National Labor Relations Act. So the National Labor Relations Board was created in 1935 to do that. And it basically does a couple of things. So the first thing on there is that it supervises and conducts representation elections. So if you decide that you want a union, the basic process is that you have to get 30% or more of employees at a particular site to sign a card saying that they want to unionize. And if you can do that, then you can petition the National Labor Relations Board to come in and conduct an election. And so all the employees are going to vote. And if 50% of the employees plus one want a union, then it is going to be created. And so then the employer has to negotiate with that union. So 30% to get the union election, then 50% plus one in order to have the union come into existence. So that's the first thing they do. So they supervise and conduct those elections. And then the second thing on there is that they adjudicate disputes between employers and employees with respect to unfair labor practices. So again, if the employees are alleging that the employers are not abiding by the terms of the CBA, then that would be something that would fall under unfair labor practices. And so you would file a complaint with the National Labor Relations Board. They have a number of regional offices. So for example, the closest one to us is in Milwaukee. And so if you had problems here locally, that's who you would go to. In terms of certification of a union, so it says voluntary recognition on there, but the type that I just described to you is National Labor Relations Board recognition. So the NLRB can recognize the union following a vote, and then the other type that's listed on the slide is voluntary recognition, which is when the ownership just recognizes a union without an election occurring. So that happens all the time in pro sports. And again, I mentioned in one of the previous videos that pro sports is probably the only business, or certainly one of the only businesses, where employers essentially beg their employees to join a union because, again, it exempts them from antitrust laws. So in the case of all four major pro sports, all four leagues voluntarily recognize the unions because it's in their best interest so that they can then violate antitrust law. All right, so if there is any sort of alleged unfair labor practice, the basic order of things is that you would file a charge of that with the National Labor Relations Board, and it has to be within 6 months of the conduct that occurs. And so anybody can do it. They just have to file a charge at the nearest National Labor Relations Board regional office, and as mentioned, ours is in downtown Milwaukee. Then the NLRB investigates because as part of the organization of the NLRB, they have staff and attorneys and agents who engage in those kinds of investigations and root it out and find the facts and all that kind of stuff and determine whether or not an unfair labor practice took place. So there's an investigation. Then there's a hearing. So the NLRB actually has, never mind. So there's a hearing with a judge, administrative law judge. And the last thing is that the administrative law judge administers the decision, and then that can be appealed either to the NLRB or to an appropriate court of appeals. So if it was found that there was some sort of unfair labor practice that took place, there are remedies that are possible. So you can get back pay if, so again, if there's some kind of violation of the pay agreement as part of the CBA, you can you can be entitled to back pay, reinstatement if the worker got fired or laid off, a bargaining order, which is that the two sides then have to go back and continue negotiating. So you see this whenever you reach impasse. We'll talk about impasse on a later slide, but basically if the two parties bargain for a while and then both just walk away from the table, the NLRB can basically order them back to the table. They have to go back and continue negotiating. And then the injunction on there is that the court orders you to stop doing something. So we see that, or we saw that come up with one of the more famous baseball strikes in the mid-90s. The owners had an injunction levied against them because they unilaterally imposed a salary cap and a number of other conditions that they wanted. All right, so a lot of acronyms on this slide. So the NLRB, National Labor Relations Board, must decide if the National Labor Relations Act is broad enough to include an industry in question. So there are a number of different industries that we're familiar with that include labor unions. So obviously pro sports, but things like auto workers, electricians, plumbers. And so if you were a worker for a recreational sports organization and you wanted to start a union, as part of the process, the first thing that would happen after you had garnered 30% support at your worksite and you presented that to the NLRB, the first thing that they would have to do is decide if the National Labor Relations Act is broad enough to include recreational sport workers. So that's the first thing they have to do. And then the next thing on there is that they would have to determine the appropriate bargaining unit. So, for example, that came up when the Northwestern University football players tried to establish a union. So they did kind of what I described to you there, where 30% or more of the players wanted a union, and so they asked the NLRB to come in and monitor that election. And the NLRB declined, and actually for the top two reasons there. They basically said that the National Labor Relations Act didn't cover amateur athletes, so that was one part of it. But then the second part was that there was a problem with the bargaining unit, and that was actually the more substantive part of what the NLRB said, is that the way that labor unions work in sports is you have a labor union for all of the NFL and all of MLB. And so if there was a union just for Northwestern University, well, what about the rest of the Big Ten? And so the NLRB declined to come in and host that election because they said that the bargaining unit was inappropriate, that the players would have to get 30% of all of Division I college football. And that would be the appropriate bargaining unit, which of course is next to impossible because of the massive turnover and the number of athletes and how spread out they are geographically and all of that. And so then that becomes basically impossible. But what Northwestern was trying to do is basically get an end run around the idea of college players as not being employees of the university. If the NLRB had come in and conducted that election, that would mean that the NLRB is recognizing them as employees of the university. So that's why they were trying to do that. I mentioned the duty to bargain in good faith on a previous slide, but I'll read you a better definition here. So duty to bargain in good faith is, quote, a willingness to enter in negotiations with an open and fair mind and with a sincere desire to find a basis of agreement, end quote. And so it requires sincerity, that you're sincerely interested in reaching an agreement, not necessarily actual results. That's bargaining in good faith. And then the last thing on there as far as fair representation goes, so unions also have to represent non-members fairly. So that's part of the different, that's part of the amended National Labor Relations Act. All right, collective bargaining. So collective bargaining is an activity, I'm quoting here, it's an activity whereby two groups, union and management representatives, attempt to resolve conflicts by exchanging commitments pertaining to the terms and conditions of employment. So as mentioned on one of the first slides, the idea here is that, one of the overarching ideas of labor law is that there can be a combative or contentious relationship between the employer and the employees because, well, ultimately they want the same thing. There can be different ideas about how to get there. So as you can see here, employees want things like better wages, job protection, and health care. Employers want to maintain solvency and, more importantly, profits, and also to have some control over the work environment because they're the boss, right? And so they want to be able to exert control. So in terms of collective bargaining, then both sides agree to meet to discuss and negotiate over those things, the terms and conditions of employment. So in terms of what is asked for, well, that kind of depends. So one of the things that affects what a union will ask for is the maturity of the union. So if we're thinking about something like the Major League Baseball Players Association, well, that's a pretty mature union. It's one of the strongest. It's certainly the strongest union in the sports, and one of the strongest in all of organized labor in the United States. So the MLBPA is pretty strong, and so they are able to ask for quite a lot, as opposed to, if you have a professional lacrosse league, for example. Let's say there's a new organization, the PLL. Let's say they decide that their players are going to establish a union, and they do. Because they're newly established, and the league itself is maybe not on the best financial ground, might be a little shaky. Both of those things are then going to affect what it is that the union will ask for. So in terms of bargaining power and leverage, I was kind of hinting at it there with my last example. But bargaining power and leverage, so if the players walk out or if the owners lock them out, so either side in citing or starting a work stoppage, what's going to happen there is that, so you get the stoppage of football games, for example, and then where it goes from there depends on public sentiment. So if the public is really mad at the owners and feels like they are taking advantage of the players, and the players have poor health care and all of those kinds of things, then the players are going to have more leverage. As opposed to what happened in 2011, the last time the NFL reached a collective bargaining agreement, there was this narrative that the owners are really effective at putting out there, which is that the dispute between the two sides was effectively a battle of millionaires versus billionaires. And so the owners tried to cast it as the players didn't really have any real grievances because they were millionaires, and so they didn't have a right to complain about anything. And so the public wasn't really then on the side of the players, and that really reduced their leverage. And so they made some concessions that they wouldn't have had to if they had done a better job, in that case a better PR job, of explaining the reality of the NFL in terms of the percentage of league revenue that they take home, their minimum salaries, how few players actually make it in the NFL for more than a year, those kinds of things. And the players really didn't do a good job of conveying those things. And so the dispute then got defined in the owners' terms, in terms of millionaires versus billionaires, and the players ended up making lots of concessions. They lost a lot of leverage there. And then the last thing is related to the league stability. So the players can't really ask for a lot if the league isn't on the best financial ground. So the first pro sport to get a union was the NBA in, what's my year on here? In the 1980s. I don't have a specific year, sorry. But what ended up happening there is that the NBA argued that a salary cap was necessary because the league couldn't continue operations. They wouldn't continue to be solvent if there wasn't any sort of cap on salaries. And so the union said, well, we don't believe you, but we'll send in some independent auditors to see if that really is the case. And the independent auditors said, yeah, that really is the case. If salaries continue to increase unchecked, the NBA is going to become insolvent. And so as a result of that, the players' union agreed, yeah, we'll institute a salary cap so that it benefits all of us, because the NBA continues to remain solvent, so we can all continue to play and watch and engage in professional basketball, all that kind of stuff. So, but if a league is really stable, so like the NFL and their $9+ billion in revenue, then typically the union is able to ask for more. All right, so I'm going to give you a quick scenario here. Obviously, we would normally do this in class, but we'll do this on a video now. So we're going to pretend that you are the commissioner of a major professional sports league, and during the off season, one of your star players did an interview with Sports Illustrated and said the following, quote, "I'm not a very big fan of foreigners. How the hell did they get in this country?" End quote. Of a black teammate, quote, "He is a fat monkey." End quote. And of the possibility of playing for a New York team, quote, "Imagine having to take the 7 train to the ballpark looking like you're riding through Beirut, next to some kid with purple hair, next to some queer with AIDS, right next to some dude who just got out of jail for the 4th time, right next to some 20-year-old mom with 4 kids. It's depressing, end quote. So, as the commissioner of this sports league, should you take action and why? And so typically when I ask this question in class, I'll tell you what normally happens. Normally people are like, yeah, absolutely, you need to take some action about this if you're the commissioner, because this is going to reflect poorly on your league, right? So this then gets lots of play in Sports Illustrated, and they say, this particular player is a racist, he's homophobic, probably a sexist comment in there somewhere, but let's go xenophobic. So racist, homophobic, xenophobic, those kinds of things, right? So all these comments, that's going to reflect then poorly on your league. You're going to get a bunch of bad press. That might cost you advertisers. That might cost you ticket sales. And so because that might cost you money, you have to sanction this player in some way. You've got to. Usually people argue that you would have to make an example of this player, that they couldn't go out there and say these terrible things that you didn't want to represent your brand, that would harm your brand, right? So next question, do you have to consider the player's First Amendment rights? So rightly you would say, wait a minute, we're talking about a professional sports league, which is not a state actor. Because remember, when we're talking about First Amendment rights, that's the first question is this a state actor that is depriving someone of their constitutionally guaranteed rights? In this case, of course, it is not a state actor. It's a private organization. It's a professional sports league that as part of their individual player contracts, but also as part of the collective bargaining agreement, there's going to be some restrictions in there on media, right? On what they can say on social media, I guess restrictions is an appropriate way to say it, but how they conduct themselves on social media and how they conduct themselves with other media, in this case, print media. So if you choose to take action, like suspending them or fining them or whatever else you might decide to do, how would you determine what sort of penalties to impose? And the correct answer is, well, you look at the CBA, look at the collective bargaining agreement, and so if there's something in there, or the individual player contracts, if there's something in either of those things that says if you do something that harms the league's reputation in the media, then that's a 2-game ban or something to that effect. So sometimes there are specifics. So, for example, in the NFL, there are now specifics on things like domestic abuse. I think that's a 6-game suspension now if you are involved in a domestic violence incident. So there may be something in the CBA or in individual player contracts about that helps you sort of anchor that. And if there's not, then you have to go on past precedent. So if somebody else in the past did something similar, what sort of a sanction did they get? And you'd have to base your sanction off of that. And so, as an aside, so obviously that really happened. So that was from December 1999, and the player involved in that incident was a relief pitcher for the Atlanta Braves named John Rocker. All right, so as far as collective bargaining agreements go, then, there are mandatory and permissive subjects. So obviously the mandatory subjects are things that have to be in the CBA. So that deals with things like the rate and method of pay. So for example, NFL players get game checks. So they get 16 really big checks, and so that's part of the CBA. As opposed to other pro sports leagues, different... the particular minor league hockey team I worked for, all the players got weekly checks. Now again, they weren't unionized, but I think it works similarly in like pro hockey and the NBA, although I don't know that. But there would be something in there about, do you get game checks, do you get weekly checks, how is that dispersed? In terms of the work rules, so like I said, the social media stuff would fall under that category, and then also the discipline related to that. So if somebody violates the work rules, so if they are involved in a safety violation, if they say something in the media they shouldn't say, those kinds of things, how is discipline applied? Drug testing, so what kinds of drugs are you going to be testing for, when are you going to be testing for them? Workplace safety stuff, so things like concussion protocols, as I mentioned earlier, who gets to sign off on that? Does the player have any sort of recourse with regard to they get their own physician that signs off on it? How does that whole process work? That's going to be in the CBA as well. If the player disagrees with a fine or suspension, how do they file a grievance about that? And then what's that whole process? What's the appeals process? And as you can see there, also health insurance, pensions, layoff compensation. And so at the bottom where it says economic weapons are permissible, That means that players can engage in a strike or picket in order to try to get some concessions from the owners on any of those things. As opposed, or in same thing, owners can initiate a lockout, keep the players from working to try to get some concessions on those mandatory things. Permissive are things that don't have to be in the CBA, and as you can see there, in terms of like change to the bargaining unit, identity of the bargaining unit, that deals with kind of the minutia of the union itself or the interaction between the union and the ownership. So those are things that don't have to be in there. And so anything on the permissive side, you couldn't use economic weapons over. And so, for example, at the very bottom, I have things like hotels, flights, tickets. Sometimes those are in individual player contracts, but they may also be in the CBA. And so you couldn't, obviously the players wouldn't strike over that. But if they were like, we're always in 3-star hotels, we want to be in 5-star hotels, we're going to go on strike, you can't do that. Economic weapons like strikes are not permissible for permissive subjects. So there we go. All right. So, as some of this stuff actually applies to pro sports, just some relevant terminology as it pertains to collective bargaining agreements. So, we talked about free agency previously. So, there's 2 types of free agency, restricted and unrestricted. And so, in the CBA is going to be how many years of service you have to have in that particular league in order to reach free agency. So, it depends upon the league. So in Major League Baseball, it's 6 years of service time before you become a free agent. In the NFL, I think the NBA as well, it's 3 years. And I don't know what hockey is. I should, but I don't. So I think NFL and NBA are both 3. And so initially you become what's referred to as a restricted free agent, which means that you can sign with other teams, but if another team signs you rather than your original team, so let's say you were drafted by the Packers, and you've reached your service time, so you're now a restricted free agent. If the Chargers want to come in and sign you, they have to compensate your original club, so the Packers in that case, usually with money and or draft picks. And so it really discourages other clubs from signing restricted free agents. As opposed to an unrestricted free agent, the new signing team doesn't have to compensate the original team. So there's a lot lower entry fee for the new team in terms of signing the player. Salary caps. So salary caps are for the entire team. How much money can you spend on your roster? So the idea with salary caps is to keep costs down. So as mentioned, the NBA got their salary cap to help keep the league solvent, to keep player salaries under control so that they weren't spending so much on salary that they bankrupted the league. Again, that's actually a violation of the Antitrust Act, but because of CBAs and because of non-statutory labor exemptions, several leagues have them. Actually, everybody except for the Major League Baseball has salary caps. Now, there's different kinds of caps, as you can see on there. So there's a hard cap, which means that if a team exceeds that number, that the contracts that they signed exceeding that number, those may be voided by the commissioner. There may be fines. They may lose draft picks. There's a number of different penalties for that. So in the NFL for the 2019 season, the most recent season, the hard cap was at $188 million. So if your team paid out more than $188 million in salary that year, there would be some kind of sanction from the league. And so teams are really strongly incentivized not to violate a hard cap. That's as opposed to a soft cap, which is what the NBA has. So soft cap is, here's what the cap is, but if you exceed it, there's a point at which you have to pay a fine, which is usually called a luxury tax. So, for example, and baseball does have a luxury tax, so in a way they have kind of a soft cap. But in the case of the NBA, so for the 1920 season, the cap was at $109 million, and teams had to pay into the luxury tax at $132 million. So if you just way overspend, then you have to spend a little bit more in terms of a penalty. So it disincentivizes teams to have a really high set of salaries, but not to the same extent that the NFL does, where they'll actually void contracts. The Larry Bird exemption is that the idea that you can go over the salary cap in order to sign your own players. So it's then not a violation of the cap. So there are some loopholes to it. Salary floor is the idea that there's a minimum you have to pay for your salary. The NFL has one of those. I didn't find the number in a quick search, but there's a salary floor in the NFL. So that's to keep teams from like completely tanking. So obviously the teams have rebuilding years, but to keep them from just completely offloading their talent and having a bunch of first and second year players, there's a salary floor in there as well. Teams have to spend a certain amount of money in order to be part of the league. In terms of caps, the way that those work is that they're defined off of, or they're calculated off of what's called defined gross revenue. And so what defined gross revenue is it usually consists of things like ticket sales, TV and internet broadcast revenue, the percentage of income from luxury suites, licensing and merchandise, so for your shirts, your jerseys, all those kinds of things, and then concessions. And so the idea here is that players want as many things as possible in the defined gross revenue pot. So if they were able to, as part of the CBA, get parking at the stadiums thrown into the defined gross revenue pot. Usually the way salary caps work is that players get, it's calculated off the percentage of profits that players get. And so, for example, in Major League Baseball, it's been as high as, that I'm aware of, the highest number I've seen for Major League Baseball in the past has been 58%. And so the players were entitled to 58% of defined gross revenue. In the case of the NFL, at the moment, it is 47% of defined gross revenue under the previous CBA. So the player's salary cap then is defined off of that 47% of that defined gross revenue. And so if you get additional things like parking, local ticket sale, or not ticket sales, but local advertising, those kinds of things thrown in there too, then the defined gross revenue goes up, so you get 47% of a higher number. So players want to get more things thrown into the defined gross revenue pot. Owners want to get fewer things. And so typically things that don't count toward defined gross revenue include parking at the stadium, which, maybe $20 to $80 or more a car, depending on which stadium we're talking about. Signage inside the stadium, local advertising and promotion, sales of programs, and then any revenue from belonging to stadium clubs. And so, as mentioned, the owners want to get defined gross revenue as low as possible. The players want to get it as high as possible. And then it comes from like I said, so one of the big things that happens in collective bargaining as far as pay goes is what percentage of defined gross revenue do the players get versus the owners. So typically it's close to a 50-50 split. As mentioned in the NFL, it's 53 for the owners, 47 for the players, although that changes with the new CBA. So under the new CBA, the players bump up to 48%. But like in the NHL, it is 50-50 under their most recent CBA. And I don't know what the NBA is. All right, so arbitration. So we talked about arbitration before when we talked about free agency. So if there's a dispute, the disagreement has to go to arbitration for most things. That's part of the CBA and part of the player contracts. And so the arbitrators are usually picked by the league. And so the idea there is to keep disagreements out of court. The disputes are settled much faster under arbitration, so that's kind of one of the ideas here. So things that go to arbitration include suspensions. So, for example, and they're older examples at this point, but a player for the Cowboys in 2014, a guy named Greg Hardy, was a defensive end for the Cowboys, and he was suspended by the league for 10 games following an investigation into a 2014 domestic violence incident. Hardy appealed using the grievance procedure. The arbitrator reduced the suspension from 10 games to 4 on the basis that 10 games was inconsistent with previous suspensions, and the NFL had only recently announced 6 games, so in 2014 is when they set the 6-game precedent, as the baseline for discipline in domestic violence and sexual assault cases. Ndamukong Suh, the incident is pictured there. That's him stepping on Aaron Rodgers in 2014. And so as a result of that, he was suspended for 1 game. But because suspensions in the NFL are unpaid, and Suh had a base salary of $12.4 million in 2014, the suspension essentially amounted to a fine of more than $700,000 because it would cost him a game check. In that case, arbitrator Todd Cottrell ruled that the suspension was excessive and instead fined Suh $70,000 for a violation of player safety. Players can also dispute incentive bonuses, which is the thing there at the bottom, if they're denied by the team. So those might include things like a player who has incentive bonuses tied to games played or catches, and the player may argue that the team took steps to try to deny payment of those bonuses, for example, by not throwing to them, by keeping them out of games. Those have happened both in the NFL and in professional baseball. So as far as arbitrators go, they have to consider past decisions within a specific sport. So as a specific example, the case I gave you basically, or the example I gave you with John Rocker earlier, he was suspended initially for spring training and then the first month of the season, because that interview happened in December, so it happened in baseball's offseason, so he got suspended effectively 2 months. And so he appealed, and that went to arbitration. And arbitrators decreased his suspension for what they called, quote, racist, sexist, homophobic, and xenophobic remarks, end quote. And they did so because of baseball's historical indifference to such things and lack of clear policy on similar incidents. So, for example, the arbitrators cited a similar issue from the early 1980s where there's a player named Bob Nepper who had made some overtly sexist comments to the media and wasn't suspended for that. So ultimately then the arbitrators reduced Rocker's suspension. And then you've also got salary arbitration. So in Major League Baseball, if a team and a player can't agree on a salary, the matter can go to an arbitrator. And so when that happens, each side presents the arbitrator with a number they think the player is worth. The arbitrator then picks one number, and that becomes the player's salary. So the arbitrator then takes an average of the figures and considers the player's skill, experience, and similar player salaries. If the arbitrator thinks the player... get that to go away. If the arbitrator thinks the player is worth more than 1% higher than the average of those numbers, then the player wins. Otherwise, the team wins. So the thing about MLB arbitration is it's kind of an interesting animal where you've got the player picks a high number, the team picks a low number, the arbitrator takes an average, and then they basically say, well, if it falls on the player side of the average, the player gets all of what they're asking for. But high stakes gamble for the player. If they feel like the player is worth less than the average of that number, then they get whatever that really lowball number the team was offering was. And so it's kind of in both sides' best interest not to go to arbitration in over salary in baseball, because the player could get a huge payday, or they could get way less than what they think they're worth, and the same thing for the team. They could get away with a steal of a bargain, or they could have to pay a lot more than they think that the player's worth if they go to arbitration. Hockey, I think, makes a little more sense. In the NHL, the arbitrator doesn't have to pick an either or, so they estimate what they believe the player is worth and then offer that as their decision. All right, so once a collective bargaining agreement has been reached in principle, then what ends up happening is this thing stays on my screen. I'll move it down there for a second. Once an agreement has been reached in principle, then the agreement is taken back to the membership. And so the agreement is ratified, it's approved. If 50% of the membership plus one individual approve of it, then that becomes the new collective bargaining agreement. And so that was the case in March of 2020, so March of this year. With the NFL, they reached a new CBA. There was some grumbling from the players about, because one of the things that happened with that one was there was an increase in the number of regular season games as well as an expansion of the playoffs. And so a lot of the players were concerned about, the wear and tear of the additional games on their bodies. And so a lot of players weren't real happy about that. And nonetheless, when that went to a vote, 50% plus one approved of it. And so the most recent NFL CBA was then ratified. Players can also decertify the union, basically dissolve the union. And so it's the same process, 50% plus one, dissolve the union. It's only happened one time in pro sports that I'm aware of, and that happened during an NFL strike in 1992. And so basically what had happened was the old CBA had expired, and the players didn't want the rules of that old CBA to continue to apply. And so the court essentially hinted to them and said, well, the rules of the old CBA are going to apply until you reach a new one, unless you get rid of your union and make a new one, because the entity that agreed to that still exists and is still part of the NFL, right? You're still represented by that same group. And so the players in 1992 dissolved the union. They decertified the union as part of their process to try to reach a new CBA. And the other thing that they did as part of that was to by dissolving the union, they were able then to file antitrust lawsuits. So that's the other reason that players would do that. All right. So a couple things here, and some of this repeats. So we talked about strikes, and we talked about so primary versus secondary strikes. So primary strikes are just the players themselves going out on strike. Secondary strike is the same thing as a sympathy strike, and we've already talked about that. And we also talked about the differences between an economic strike versus one over unfair labor practices, and it pertains to whether or not the employees can be permanently replaced. What we haven't talked about, though, are lockouts. So lockouts are where the employer prevents the employees from working. So rather than the players walking out, it's the owners who have stopped the games. They're less common, but they do occur. And so you can see there's two types on there. The first type is a defensive lockout. And so what happens there is that the employer fears a strike by the players or the employees when the ownership or when the league is most vulnerable. So in sports, that might be right before the playoffs. And so then the owners initiate a lockout at a time that's better for the team or for the league, which is usually the off season. So as an example of that, the defensive type of a lockout, that happened in the NHL in 2012. And so those pictures are from that or are related to that. So in 2012, the NHL owners locked out players for 113 days, resulting in the cancellation of 628 games. So the league wanted the players' share of hockey. Actually, this is more of an offensive strike, sorry. But nonetheless, I'll keep reading you the example. So the league wanted the players' share of hockey-related revenue to drop from 57% to 49%, and eventually down to 47%. Termination of salary arbitration. So obviously that would disadvantage the players. And then expanded criteria for reaching unrestricted free agency. So the teams would have control of the players for longer. Eventually, they settled on a 50-50 split of the revenues, which left $230 million less for the players as a group, a hard salary cap at $64.3 million, and a 7-year limit to contracts. All right. So again, defensive strike. Employer fears that the employees are going to, or sorry, not defensive strike, defensive lockout. The employer owners feel like the players are going to go on strike, and so rather than allowing the players to strike during the season or before the playoffs or whatever, they lock out the players in the off season. So they try to minimize losses there, as opposed to an offensive lockout. So what's happening there is the employer is trying to exert economic pressure on the employees. So usually owners have a lot more cash in reserve than the players do, and so because of that, if they don't pay the players for a long period of time, usually the owners can sustain not playing games for a lot longer than the players can. And so the offensive strike, they're locking the players out to exert economic pressure to try to force them to fold, which is what happened with the hockey strike there. All right, and then the last thing. So if both sides have bargained in good faith, but ultimately reach a deadlock, that's referred to as impasse. So that does happen sometimes, and so you can see that the most notorious, I guess, example of impasse between players and owners comes from the baseball strike from the mid-1990s, so the 94-95 strike. And so what happened there is, as you can see, the owners wanted a hard salary cap. So the NFL had just gotten their cap in 1993. So the NBA got theirs in the 80s. The NFL got theirs in the early 90s. And so baseball wanted one too, but they wanted a hard cap to really minimize salaries, just like the NFL had, where there would be significant penalties and all those kinds of things. At that point, players got 58% of defined gross revenue, and so the league wanted to knock that down to 50%. And one of the things that the owners argued was that a hard salary cap was necessary for competitive balance, that you wouldn't, if you had a hard cap, then that would keep teams like the Yankees, the Red Sox, the Dodgers from just outspending everybody and winning every year. And the Players Association basically said, not our problem. Our job is to maximize the amount of money that our players make, and we don't really care about competitive balance. And so both sides continue to bargain over that, ultimately reaching impasse, and the result is that there is a strike. The end of the 94 season is canceled, no World Series that year. And so then in the offseason, ownership just does all the things that they wanted to do. So since there was no CBA that was reached, there was no agreement that was reached, the ownership just instituted all the changes that they want. So they instituted the hard cap and then the other changes that they want. The players then petitioned the National Labor Relations Board. They argued that that was an unfair labor practice, that the owners couldn't just unilaterally impose their will, impose these new restrictions. And so the NLRB agreed, and they issued an injunction against the ownership and also in a bargaining order. So the two sides then had to go back and bargain. And so ultimately, Major League Baseball plays the 95 season without an agreement, and they reach a new collective bargaining agreement near the end, or actually after the end of the 96 season. And so the result of all of this labor strife over the course of 3 seasons from 94 to 96 is that attendance declined pretty significantly. So from a pre-strike average of 31,600 fans per game in 1994 to 26,800 fans per game in 1996. So puts a pretty big dent in the income for Major League Baseball. And so one of the arguments is that strike then led to the steroid era, because then you start to see, Mark McGwire and Sammy Sosa and all of that in the late 90s. You start to see the single season home run chase and all that in the late 90s. And so some have argued that baseball, the commissioner and baseball executives basically turned a blind eye to the steroid use that was happening because it helped generate more interest in baseball and helped get fans back into the parks and all of those kinds of things. All right, so you made it. That's the end of labor law. So good luck on test 2. And as always, email me if you have any questions or need anything.